Hello and welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is the fourth in our 5 Perfect Days of Education, and it's an EDRM collaboration with eDiscovery Today's Doug Austin. Important eDiscovery case law decisions for September 2022. Our faculty experts are Doug Austin, the illustrious Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the console, and as always, this webinar will be recorded and available for replay at your convenience, as are all of our webinars. Please take a look at the Attachments tab, and that's your little paperclip, for a link to subscribe to eDiscovery Today. Keep up with eDiscovery news and education. Also, how you can engage Judge Peck of DLA Piper to assist you. There's a link to Tomo's Spicy Techno Gumbo blog, and up tomorrow on the last one of our 5 perfect days, is there any right to privacy in modern eDiscovery? And we also have a rip from the headlines. Facebook engineers not knowing where, they have no idea where all your personal data is. And then, of course, with all of that, Doug brings it together with eDiscovery Today's great white paper, Getting a Clue, regarding eDiscovery project management. So he's got a nice white paper there. And at the end of the webinar, you can download a certificate of attendance from the top of the screen on the console to use for your continuing ed requirements. Now, Doug Austin, he on the left is an established eDiscovery thought leader with over 30 years of experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and government clients. Doug has published an award-winning daily blog, and since 2010, he has been posting at least once a day. And our friend Tom O'Connor, in San Francisco today, but hailing from the great city of New Orleans for over 3 decades. He has stewarded the Gulf Coast Legal Technology Center, has a wonderful YouTube channel that has great long-form interviews, and he is a sought-out consultant on some of the toughest cases that our eDiscovery community faces. And the Honorable Judge Andrew Peck, retired as a United States Magistrate Judge in the Southern District of New York after 23 years. He wrote many of our earliest eDiscovery opinions, and then later in his tenure, he wrote on boilerplate objections, 502D orders, and technology-assisted review. At DLA Piper, Judge Peck advises on copyright and trademark matters, and also serves as a resource for the firm and its clients on litigation strategy and discovery issues from his unique judicial perspective, and he is Chambers ranked. All 3 of these gents are serving on our EDRM Global Advisory Council, and Kaylee and I are very grateful for that, as is our community. And without further ado, Doug, you have put together a couple of cases for us to talk about.
More than a couple, Mary, thanks. And yes, we do have some really interesting cases this month. We don't have a case involving a horse in discovery this time, but we do, but we do have a couple of defendants who may have been horsing around with their discovery obligations.
Okay, that's one.
Or a counsel that was the rear end of the horse.
Oh, yeah, indeed. I didn't mean to put the cart before the horse, but anyway. Our 6 cases involve disputes including beyond meritless and utterly frivolous objections, 2 cases involving the use of 502D orders for privilege waiver protection. Gee, I wonder who suggested those. 2 rulings in a fairly obscure, little-known case involving Twitter suing Elon Musk. That happened on the same day, no less. And a default judgment involving repeated discovery misconduct, including failure to produce a smoking gun Slack exchange. And just a reminder, we will send out copies of the slides after the presentation, so look for that. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. Failing to say that would be beyond meritless, while reminding you of that is never utterly frivolous. And before we get... Before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistant site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has nearly 25,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So, with that said, let's get into the cases. This first case is one of 3 cases suggested by Judge Peck this month, which saved me a lot of time, so thanks, Your Honor. This one is an intellectual property dispute involving the plaintiff company and their former director, officer, and founding shareholder that left to form a competitor company. In it, the parties proposed and the court approved and entered a protocol for the inspection of various defendant devices. After the plaintiff noted that defendants had failed to comply with the terms of the preliminary injunction order, the court adopted the inspection protocol as an order of the court. The eDiscovery consultant conducting the inspection created a spreadsheet list of files to be produced to both parties, but the native copies were first produced to the defendants so that they could mark their copy of the inventory with their assertions of either privilege or privacy. In August, the parties filed a letter brief that California Magistrate Judge Robert Illman stated leaves little room for doubt that defendants have violated the letter and spirit of the protocol in their zeal to obstruct plaintiffs' access to evidence, noting that defendants' counsel marked thousands of items in the inventory as private and repeated the same boilerplate, nonspecific explanation as to each designation, violating both the terms and spirit of the protocol. The eDiscovery consultant also produced a report in connection with its analysis, first to defendants, and defendants refused to tender a copy to plaintiff or to allow the consultant to do so based on a curious assertion of work product because the consultant reportedly addressed it to defendants. Judge Illman stated, before proceeding to defendants' arguments, the court will begin with the observation that they are all beyond meritless. The arguments cannot be characterized any way other than utterly frivolous, noting that defendants and their counsel should take great care to avoid wasting the court's time and resources in this manner going forward. He also used phrases like blusterous noise, gross misconduct, and without anything remotely resembling a coherent explanation to describe the defendant's conduct and arguments. Gee, Judge, what do you really think? He also ordered the eDiscovery consultant to immediately disclose its analytical report to plaintiff, and for all entries for which defendants provided a nonspecific or boilerplate designations, ordered the defendants to immediately tender the entirety of that material to plaintiff without further objections or delays. Judge Illman also granted the plaintiff's attorney's fees associated with addressing the boilerplate objections and warned the defendants that playing games with the court is a dangerous endeavor and threatened harsh sanctions upon defense counsel and upon defendants for any additional misconduct. So, Tom, it seems as though we're seeing more of these issues happen in IP-related cases. Do you agree? And do you think it's often because defendants are doing everything possible to avoid disclosing their activities related to allegedly stolen IP?
Well, I'm not sure whether we're seeing more in IP-related cases or not. I just don't read as many overall cases as you do, Doug. You mentioned in a conversation with me the other day that you're reading 50, 60 or more a month decisions. And so you probably have a better sense statistically if there's been an uptick in IP cases with these sort of issues. I just, I don't have any statistical basis for making that statement. As to whether it's doing everything possible to avoid disclosing their activities. Was it last month we had the Hollis case or the month before? Recently, we had the Hollis case where the judge referred to Hanlon's razor.
Right.
The adage that our old friend Browning Marion loved to quote, but basically never attribute to malice that which can be explained by incompetence, right? And boy, oh boy, I think this one's drifting over to the incompetence side. I mean, the judge you had great quotes. He quoted thousands of boilerplate and non-specific privacy designations. That the quote I loved, you quoted in part, defendant's portion of the brief ventures beyond the outer boundary of frivolous argument to where it is squarely situated on grounds that can only be described as nonsensical. And then what the quote that you had, without anything remotely resembling a coherent explanation. I'm not sure that's malice as much as the alternative.
Tom, I would actually disagree with you.
Okay.
If nothing else, the argument that the court appointed or the other side's experts report was work product because the expert sent it to defendant's counsel first. That to me is pure obstructionism. No lawyer, even a first-year law student would know that that is not their work product. So I think you're being too nice to these bozos.
And fair enough. I mean, I think your perspective on this is most welcome and probably mirrors exactly what the judge was thinking in this case, right? So I'll defer to your take on that, Judge.
Well, let's see what Judge Peck has to say. So I'm curious, Judge Peck, have you ever admonished a party like this over discovery issues? And would you have given the defendants another chance, which essentially he did, like Judge Illman did?
Well, first of all, I tended to rule from the bench so that the poor counsel getting a tongue lashing does not have it spread all over Westlaw and, other sources. But I mean, I think Judge Illman here made it very clear what he thought of these people. And as to second chances, I mean, he gave them a second chance, but would you want to be the lawyer to make an objection when the judge warned, quote, if any of their arguments are found to be willful obstructionism or bad faith or relying on arguments that are frivolous, the court will not hesitate to visit harsh sanctions upon defense counsel and upon defendants, including hefty fines, close quote, and also talked about contempt sanctions. It would be a very brave or a very stupid lawyer who makes arguments to the judge on the second chance they were given with that hanging over their head.
And Judge, I wonder, I had highlighted that last quote that you put in there about defense counsel and defendants. I mean, is your take on that the counsel and the defendants were acting in cahoots to do this? Using an obscure legal phrase.
Yes, I mean, it would be pretty rare for the client not to have some idea what their counsel was doing.
Right.
So, when one starts to have to figure out who do I want to sanction, the attorney or the client or both, you got to go through those sort of considerations. And, going back, I don't know how many years now, Qualcomm against Broadcom,
right.
Wound up with the attorneys being allowed to breach the privilege to defend themselves for what they said was their client's fault, not theirs.
And I also thought of the Qualcomm case because at this point, if it is malice to that degree, in Qualcomm, the court reported several of those attorneys to the California bar, as I recall.
Although that doesn't happen nearly as often as it probably should.
Now, that was my question. You think that's something that should happen more often? Yeah.
You hate to put the judge in that position.
Right.
And then is that a ground for recusal? No, but it's a ground for a recusal motion, which the court will then deny. The adversary counsel certainly is free to refer it to the bar.
Good point.
Sure.
Good point.
Yeah. No, that's a great point. Let's take a look at a little bit of a different angle. Certainly, Mary, we see cases regularly that require a third-party eDiscovery consultant to collect data. So what recommendations do you have for our audience on how to ensure that they provide their services in a manner that's fair to both parties?
Well, we've got the technical person in the center, in the middle. And so before engaging, imagine what could go wrong or what latitude might be taken by either side. And so here they were supposed to do a full inventory. It's plain on its face, but and then looking for specific objections to hold back items on a file by file basis. And so, yes, you could maybe give some examples of what boilerplate looks like and what something that is not boilerplate, that's more specific, might look like. And then having the judge, who's doing the appointing, or in your negotiations with the parties, to have some kind of some penalties for boxing up the works. Whoever it is should have a direct line to the person or judge appointing them to get clarification when things get sticky. It should work off a retainer, because no one's going to be happy with what they do. And then have the judge be the one to decide the reasonableness of the bills rather than the parties. And I would also put in there a higher dollar amount for court time and reports, to defend the work, not to do the work and to give the report, but if it's discovery about discovery, it could go on forever. So those would be some of the things that I would suggest. Oh, and one more thing: preset meeting times and reporting formats with timing intervals, and then observe that so that it's not as interrupt driven as it could be.
Those are great points. That last one's great point in all sorts of meetings. So yeah, absolutely great advice. All right, so let's move on to our next case, which is the first of two decisions involving Rule 502D orders to protect against waiver of privilege, both suggested by Judge Peck. This first one is a privacy litigation dispute involving Google, where the parties disagreed on essentially the receiving parties using the contents of the document clawed back as privileged to challenge the privilege. And California Magistrate Judge Virginia DeMarchi rejected the plaintiff's proposed text that would permit them to do so, and adopted Google's proposed text, but also rejected Google's proposed text that would prohibit the plaintiff from presenting the clawed back document to the court for decision on the dispute of privilege, because it would be inconsistent with FRCP Rule 26b5b. Google eventually proceeded to ask the court to enter an order under Rule 502D that included only the terms as to which the parties previously agreed. Google argued that the Rule 502D order was necessary to ensure that document production could continue to be conducted without exhaustive pre-production privilege review and without the need for fact-intensive inquiry about whether a party has satisfied Rule 502B's reasonable steps requirements. The plaintiffs opposed entry of the proposed order on two grounds. First, they argued it was procedurally improper for Google to move for a 502D order, and they also argued that such an order was unnecessary, as the parties had already had the legal tools and resources they needed to resolve disputes over privilege waivers. Addressing the plaintiff's first objection, Judge DeMarchi stated there's nothing procedurally improper about Google's motion for entry of a Rule 502D order. She also said on the merits, the court agrees with Google that entry of a Rule 502D order is warranted in this case. While such an order may be unnecessary in cases where privilege disputes are likely to be few and easily addressed, or where the parties have demonstrated the ability to cooperatively resolve disputes without the court's intervention, this is not such a case. So because Google's proposed 502D order included only the terms on which the parties previously indicated they agreed, and plaintiffs do not object to any of those terms, Judge DeMarchi granted Google's request for the 502D order. So Judge Peck, Google is involved in a lot of litigation, and as I understand it, they can use this waiver of privilege protection under Rule 502D in other cases too. So does that put opposing parties in those cases at a disadvantage, since they don't even get the opportunity to contest 502D protection?
No, because the 502D protection in one case, so in this case, only protects documents that are produced and then clawed back in that litigation. So in that sense, the outside party, the party in the other cases against Google, is stuck with that result. But it does not mean that a document that Google mistakenly produces and tries to claw back in those other litigations is protected by this 502D order. There would have to be a 502D order in the other case in order for there to be that protection for newly produced documents in that case. I'm not sure I'm being clear in my explanation, but I'm trying to differentiate between the protection that a clawed back document in this In Re Google case has that protects it from being a waiver in other cases versus documents being produced for the first time in those other cases.
Yeah, no, actually, that was very clear. So I appreciate making the understanding the distinction there. So, Mary, it seems like we're seeing more cases involving requests for 502D orders. Do you agree? And do you think large companies like Google are using them to keep litigation costs more manageable?
Well, I absolutely am seeing more 502D orders. Thank you, Judge Peck. And certainly it does reduce the cost of a review. Privilege review is the most costly part of review, and then needing to quality control it so that and create documentation that is court consumable. That really does jack up the cost. So. Google's argument was that they would suffer prejudice because they had reviewed under looser standards, and then they'd have to go back and ratchet that documentation into something that they had already done. So I do think organizations are using it to reduce costs, but more than that, risk.
Yeah, if I can jump in there, I see very little difference in most cases, most quote unquote big law cases. It's more the protection against the arguments that you have waived, as opposed to, okay, we've got a 502D order. Our priv review can be less thorough than it otherwise would. I don't think there are many big law cases where that's the situation. There may be situations where the client has a budget and is not that concerned about a privilege waiver and is happy to just have the protection of 502D. But I can't think of any of DLA's clients who would say, yeah, you can be a little less good on your priv review than you otherwise would because you're protected by the 502D order.
Right.
Interesting. So I'm curious, Tom, why do you think parties would object to a 502D order? It seems like it benefits all parties.
Well, let's bring Hanlon's razor back into play. My first thought was, do they just not understand it? Do they don't know what's going on? I think, and Judge Peck probably disagree with me on that one again here with these folks, right? The judge made short shrift of their procedural argument, kind of disdainfully, I thought, and then sort of alluded to in the quote that you read, where you may not need a 502 in areas where the parties have demonstrated the ability to cooperatively resolve disputes. Obviously, saying that's not the case here. They haven't been cooperating. They've been dragging their feet, being obstructive, whatever, which would tend to indicate that they're fighting the 502 just because they're fighting everything and not being cooperative about it. So I think it depends on the facts of the case, which it would be interesting to dive a little more into that. What's your sense of that, Judge? Am I being too nice to the law firm again?
No, I mean, but I think, I don't know anything about the case other
Yeah.
than what's in this opinion.
Yeah.
But with the heading of In re Google consumer privacy litigation, I am assuming it is a purported class action by individuals
Yep.
who are unlikely to have much in the way of privileged material. So it's sort of a what's in it for me as the plaintiff to let Google have the
Right.
risk reducing 502D order. And I
Right.
think that the asymmetrical litigation are classic cases where the plaintiff sees no need for a 502D order.
Right.
Yeah, that's what I wondered. I thought maybe it was more, they were more likely to object when they didn't have much to worry about producing. So I was thinking maybe asymmetrical litigation could be the reason. So yeah, very interesting perspectives. And hey, let's talk more 502D because our next case is the other one. And this one involves the Monsanto companies and claims of contamination from PCBs. So here the defendants, after conferring with the plaintiff regarding a proposed Rule 502D order, filed a motion to request that Rule 502D order with the court, arguing good cause existed for a grant of the motion because their proposed order would afford the parties the full protections of Rule 502D and therefore serve the parties' best interests. Once again, the plaintiffs disagreed, contesting defendants' request for a 502D order, suggesting that defendants provided boilerplate language regarding good cause and the best interest of the party, but had not otherwise explained why a Rule 502D order was necessary. They also argued that the parties are automatically protected from waivers caused by the inadvertent disclosure of privileged information under Rule 502B, and that Rule 26.5B also provides a mechanism for resolving disputes related to the inadvertent disclosure of privileged information, and that those protections were sufficient in this case. Regarding Rule 502D orders in general, Illinois District Judge David Dugan stated, Subdivision D of Rule 502D of 502 enables the court to enter an order that allows the parties to conduct and respond to discovery expeditiously and without the need for exhaustive pre-production privilege reviews. While noting, even after the entry of a Rule 502D order, a completely reckless disclosure or a disclosure made irrespective of the reasonableness of counsel's privilege review may nevertheless result in waiver, such that a counsel who produces documents without even a reasonable privilege review does so at his or her own risk. Judge Dugan also stated, such orders are increasingly important to limiting costs of privilege review and retention, especially in cases of electronic discovery. As a result, he granted the request for the Rule 502D order and outlined and ordered a process involving claims of privileged information being disclosed, including the process to generate a privilege log and claw back such materials, contesting privilege claims, and addressing disputes over those privilege claims. So, Mary, do you agree with the plaintiff that Rule 26B5B pertains here, or is it irrelevant given that it's about the mechanics for resolving privilege disputes, not about waiver of privilege itself?
Well, without the 502D order, you'd need those mechanics for resolving privilege disputes. And even with the 502D order that was granted here, the judge wrote out his own process. So I think there has to be some process, and if you don't have anything else, 26B5B is good.
Okay, well, that makes sense. So kind of picking up a little bit of the discussion from last time, Tom, how exactly, if we talk about limiting the costs, how exactly does a 502D order limit cost of privilege review? Would you conduct privilege review differently with a 502D order than without? And if so, how? I'm curious really how it does reduce costs if we're really trying to do still a reasonable privilege review.
Well, I think the theory is, as Mary pointed out in the previous case, privilege review is the most expensive part of review, and review is the most expensive part of the whole e-discovery process. So theoretically, if you can, as the court said, abate the time and resources doing that, especially in a case like this where there were, quote, millions of pages of documents, which raises, again, as Mary said, the risk factor. The more documents, the more chance there could be an inadvertent production. Theoretically, you would be able to not worry about that as much, and I guess push through the review. But I thought Judge Peck's comment previously was the most telling, which is, I don't think any of my clients are going to agree to that. Like, hey, we're going to save a little bit of money here by not being quite as diligent in the review, as scrupulous, as worried about it. I just don't know if that's going to play. And I think, and correct me if I'm wrong, Judge, I think I heard you say that's not going to play, at least with the clients that you discussed this with. So, I mean, it seems like it's an interesting theory, but, is that really going to work? If anything, it would seem to me this is a place where you want to use technology to help in the review. If you want to abate time is money. If you want to do things faster, then use tools that, will help you do things faster by definition. And that's where technology comes into play.
It's sorry. It's interesting you say that, Tom, because there are at least two vendors that I'm aware of that have a sort of tar for privilege tool.
Right.
And that can certainly be used. Of course, the difference is, if you're doing a regular review and you get, we've produced 80% of the documents. Everyone is very happy. That's a great result. If you're doing a priv review that way, and you have to tell your client, well, 20% of our privileged documents, your documents, were produced, not so good.
Yeah.
But, certainly one could combine that technological development with the 502D order and with additional review to prevent that 20% from slipping through to try to save money on it.
You think clients will go for that?
Yeah, I mean, I know, I'm not going to mention the vendor
Yeah, of course.
here, but I know that they have been very successful selling their product to companies to be used in-house, where the buildup of knowledge from case to case allows it to be very effective. Not quite as good, when the outside counsel wants to use that software and doesn't have all the historical client information about, who are the lawyers who used to be in-house, who are gone, and, et cetera, et cetera.
Okay.
All right. Well, so Judge Peck, you talked about this a little bit on the last case, but certainly Judge Dugan stated that a counsel who produces documents without even a reasonable privilege review does so at his, her, or her own risk. So, I mean, I thought the whole point of 502D is you didn't have to be as reasonable or careful with your privilege review, and you're still protected. Is that not necessarily the case?
I mean, it is, and I'm not a big fan of this completely reckless standard. I mean, one has the ability, and if one reads the Congressional Advisory Committee notes, a purpose of Rule 502D, not a purpose that it's actually being used for, would be allow one to do what we used to do in the paper world, now doing it digitally, produce all the documents basically without review, and tell the other side that once they told you which of that production they really wanted to keep, you would then do a privilege review to cut down how much you got to do. Nobody does that. So, but, you could produce under a 502D order with no privilege review or a half-assed privilege review. So this, completely reckless standard, I haven't tried to figure out where it first came from, I mean, Judge Gorenstein, in a case we discussed a month or two ago on this broadcast, used it. Our friend Judge Johnston, in the short DR distributor marital privilege case, citing to Gorenstein's decision, talked about this completely reckless standard. Doesn't really make sense to me.
Yeah, and like you said, just because you could conceivably do it, who would want to? Certainly, I've seen some cases where parties have suggested that the responding party do it that way, but they never seem to agree to do it that way. So it certainly makes sense. All right, so let's move on to the first of two rulings in the fast-moving and highly public Twitter versus Musk case. And these two rulings happened on the same day earlier this month. In fact, there have been 13 rulings on eDiscovery issues in this case since August 15th that are in eDiscovery Assistant. So expect us to discuss possibly one or two more in the next month's webinar. This one dealt with quote unquote clear deficiencies in the defendant's production, including text messages with Musk produced by third parties that Musk did not produce. In one, Delaware Chancellor Kathleen McCormick describes a text exchange between Musk and another party where you see the other party's text with the second one saying, okay, got it, but no text in between. Chancellor McCormick stated, assuming that Musk's response was not telepathic, one would expect some evidence of it in defendant's document production, but defendants provided none by the deadline for substantially completing document discovery. She also said defendants' approach to answering interrogatories also left much to be desired, noting it took 3 tries to identify 491 people with knowledge. She also rejected defendants' contention that plaintiff was jumping the gun and seeking sanctions, stating plaintiffs collected, reviewed, and produced documents from 42 custodians. Defendants agreed to produce from just 2 custodians. Defendants had less to do but still fell short in their obligations. Defendants' prior deficiencies have left plaintiffs wondering whether there are other deficiencies and scrambling in third-party discovery. So ultimately, Chancellor McCormick granted 2 of the plaintiffs' 4 requests, denying its request for all text messages from defendants' 2 custodians and immediate custodial deposition of Musk, while granting suspension of third-party discovery deadlines as to plaintiff, and for the defendants to obtain and produce phone company records concerning the text messages that Musk and his right-hand man, Jared Birchall, sent or received during the relevant period. So, Tom, one of the requests that was granted that I just mentioned was for defendants to obtain and produce phone company records concerning the text messages. Shouldn't that always be a third-party request in cases involving text messages, or should it only be requested if there are concerns that the production isn't complete?
Well, from the perspective of the people making that request, who I tend to work with a little bit more, we always ask for them. Yes. Mm-hmm. I mean, it saves time, number one. If you're going to wait for a response and then do a gap report or look at it, in this case, look at some of the other material that gives you some sort of an indication that there's something not correct there, he said tactfully. And then you've wasted time where you have to now go back and ask for the records. I asked for them first, and let's at least do that. I mean, here we just have a bald assertion by Musk or his representatives that, well, we didn't text about that. So I just think it behooves you to ask for those records right away to streamline the process. Obviously, we get a lot of pushback on that.
Sure. Yeah, but it's
go ahead. I'm sure the phone companies love getting your subpoenas.
Yeah. Oh, they just are overjoyed to see that request go in.
But just correct me if I'm wrong, Tom, but so the audience knows, it's my understanding that other than if you get to the phone company, within 30 days of the text message being sent, generally all the phone company will have is that there was a text message between party A and party B, but not the content thereof.
Let me just say that's what the phone company will say to you. Whether that's always accurate or not is up for discussion, but it certainly is a reason why you want to make that request immediately, to have them preserve it and produce it as quickly as possible. Given the fact that there's probably, I guess what I'm saying is I'm not sure that it's always a strict 30-day policy, but it's going to be a short porch, and you want to make sure to get your request in and get that frozen before they do get deleted. Yes.
Yeah. Which is great advice, and still the fact that a text was sent between parties can be useful, and confirming that they didn't produce them all. So even if you don't get the actual content of the text, the actual log of the text's recipients, senders, receivers, is useful.
Yes.
So,
and counters the representation as here that there were no texts.
Right. Absolutely. Yep. So Judge Peck, in a fast-moving case like this one, how would you handle issues such as the delay in identifying the number of people with knowledge? Would you be quicker to sanction for delays in cases like this than you would be in other cases that are moving at a slower pace?
On the one hand, time, work expands to fill the time allotted. But here, where there is a set trial date that the Chancellery Court is not going to move almost no matter what happens, it puts pressure on the parties and therefore on the judge to keep the case moving. And really all you can do is, as they appear to be doing here, rule very quickly when disputes are raised, perhaps bring the parties in, every week for a conference to find out where things are and rule on whatever disputes there are. It does put the pressure on everybody.
Sure, I would think so. So Mary, Chancellor McCormick ruled that the plaintiff couldn't conduct a separate custodial deposition on Musk. Given the discovery issues, do you think she should have granted that request so that the custodial issues didn't interfere with a deposition regarding the facts of the case?
Well, this is interesting to me because what the judge said is that the plaintiff will be deposing Musk quite soon, given the case schedule, and that the questions about custodial records and who's involved could be asked at that point. I don't know if I've heard of something called like an immediate custodial deposition, and so I'd like to ask Judge Peck, have you heard of something like that?
Yeah, although it's not granted very often because in a way that's discovery upon discovery. So there's got to be, in my view, a showing of some defects to be allowed to explore that. But it can happen. If this case were on a slower track, I suspect that the chancellor would have allowed that sort of early deposition to find out who has knowledge and where the documents are, and then get to the merits later.
Yep. That's again one of the things you wonder about with a case like this. So getting some great questions from the audience. One here, is it not normal that most e-discovery cases, federal or state, that third-party document collection and productions, if their productions contradict one or both parties' production release and shows glaring inconsistencies and hypocrisies, that this is part of normal discovery and part of the normal doc review? Why in this case would this be any different? So I guess what they're asking is, isn't this normally something that would be used if they're contradicting the production? So I guess my question is, do you get battles like this where a party, like Tom says, would request the phone logs and the other party would fight it? What do courts typically rule absent some reason, some deficiencies? Judge Peck, do you have any thoughts on that?
Yeah, the Sedona Conference commentary on Rule 45 has opined that, and consistent with much of the case law, one should not, go to non-parties for information that one can get from the parties absent a showing of particular need, often because of a failure in party production. But, it is not inconsistent with practice immemorial to get information from a non-party that shows that one of the parties has not kept and therefore has not produced much of what once existed.
Yeah, no, it makes sense. So got some other great questions. We will get to them here in a bit, but we do want to get through our last couple of cases. So I'm going to move on to, hey, the same case, but a different ruling. So this time there was a dispute where the plaintiff's custodians used Slack for relevant communications, and the plaintiff agreed to produce responsive Slack messages from 6 of their 42 custodians, while defendants sought production of responsive Slack messages from all 42 custodians in their fourth discovery motion. The plaintiff argued that the additional production would be unduly burdensome and observed that because defendants previously demanded Slack messages from only 8 of plaintiff's custodians on August 18th, they shouldn't be permitted to request messages from all 42, which they reverted back to on August 23rd. Noting that defendants' explanation for those later communications, requesting only 8 custodians, was that they inadvertently failed to remove the language, Chancellor McCormick stated, even if defendants' representations were inadvertent, defendants cannot be permitted to retrade now. To be sure, generally, parties should be able to offer compromise positions without prejudicing their right to move for the full scope of relief to which they are entitled. This is not what happened here. Defendants gave plaintiff the impression they were seeking limited Slack custodians, only to then say that they never meant it. In this highly expedited case, there is no time for just kiddings. Parties must be able to rely upon one another's good faith proposals for the discovery process to function. Defendants are therefore held to their proposal, seeking Slack messages from the 8 custodians identified in their proposals. As a result, Chancellor McCormick ordered the plaintiff to add the 2 additional custodians to their proposed 6 to get to the defendant's 8 custodians. So, Judge Peck, do you generally take the position like Chancellor McCormick did, that once a position is offered, you can't go back on it, or does it depend on the circumstances of the case?
The answer is always.
I like a rhetorical question every now and then, Judge.
Yeah. I think there is a difference between a proposal that the other side rejects. If you say, okay, if you agree to give it all to me now, I will only ask for 8, and the other side says no, you could then go to the court and say, I offered to accept 8. They didn't accept that proposal. Now I want more. But here it was sort of a agreed upon amount. At that point, I think you'd have to show that something was in the documents from the 8 custodians that clearly pointed to somebody else as being an important witness, important custodian. And then I think you would be allowed, or you potentially would be allowed to add that person or persons into the mix.
Yeah, that seemed to make sense. And certainly in this case, they didn't do that. So they were stuck with the 8. So, and certainly, Mary, the defendant claimed its reduction down to 8 custodians was inadvertent. So what advice do you have for our audience to keep from making mistakes like that during scope negotiations?
Well, one might write down their agreements immediately. That would be a good thing. Right. And agreements aren't orders. It's always best to have it all baked in. But when you talk about reducing cost and the material, after you identify the claims and defenses that are in dispute, date range and number of custodians and data sources are the most important cost drivers. And so I think it's really important to write them down and get them baked in.
Yeah, no, I think that's a great point. So, Tom, if the defendants hadn't inadvertently asked for 8 custodians, do you think they might have had a chance for all 42 custodians, given how many communications are happening within Slack these days?
I'm not sure, given what the court referred to as the case being highly expedited, and Judge Peck just made note of the fact that this was a case with deadlines, and the court was under pressure to keep this moving. I'm not sure they were going to take the time. I'm not sure the chancellor was going to allow them to take the time to go through all 42 of those, and wouldn't have tried to force some sort of a middle ground. One side's offering 6, and the other side's offering 42, or asking for 42. It seems unlikely to me in this case that the higher number was going to prevail.
Yeah, well, that's fair. Certainly seems like so many communications are happening in Slack these days that maybe the defendants could have made a more effective argument for a higher number of custodians at the very least, since so many teams are communicating that way. But obviously they asked for the 8, slipped up and asked for the 8, so they got stuck with the 8. So,
well, and I think Judge Peck also made the point, like, focus in on who's important, why are they important?
Right.
You're asking for 42, but why? Was that just an entire department of people? Where did that number come from? And can't we focus in on, maybe there's 20 that are important for these particular reasons? I think you'd have to back that up, especially in a case like this where it needs to keep moving. It needs to meet deadlines.
Yeah, absolutely. Makes perfect sense. All right, so that'll take us to our last case, and it's one of the more unique cases we've covered all year. To start with, it's so long that Massachusetts District Judge Mark Wolf needed a table of contents to cover it all, which is usually a bad sign for one party in terms of their eDiscovery failures. We've seen that before in other cases. He also stated that there were more sanctions in this case against the defendants for failure to produce documents than any other case in which this court has presided in more than 37 years, which he said 4 times within the ruling. In this case involving misappropriation of trade secrets by an employee of the plaintiff, allegedly using the plaintiff's proprietary software to place mock trades for defendants, the defendants had a series of discovery missteps in this case. Defendant Mueller filed a sworn affidavit on behalf of all defendants, claiming to have complied with the discovery requirements set forth in FRCP Rule 26E, but the defendants kept having to produce documents as the plaintiff discovered their existence, including 47 documents that included 14 still images of the plaintiff's system, an Excel file that appeared to be an export of certain data from the plaintiff's software, and a PowerPoint that included screenshots of the plaintiff's software. The defendants also kept supplementing with additional productions of messages from their Slack communications platform, with the defendants citing difficulty in conducting discovery from Slack as one of the main reasons for the issues. Eventually, the court ordered the defendants to provide the plaintiff with a copy of the 2019 Slack archive to be searched by the plaintiff's litigation data provider, which found 87 empty folders in the defendant BIA's Slack archive, and also that BIA failed to produce at least 128 relevant messages that contained a search hit, including a quote-unquote smoking gun Slack exchange in which defendants Greg Mueller and Michael Herodon discussed creating a new algorithm to hide the fact that the original algorithm was derived from the plaintiff's intellectual property. In the exchange, Mueller asked Herodon, "Would it be possible for you to create another algorithm from scratch? We are trying to come up with ways to make this go away. We would need to be able to convince an outside observer that it was from scratch, not really sure what that would mean." And Herodon responded, "If that means not derivative from IP, then I think so." That sounds pretty smoking to me. So regarding all the defendants' discovery misconduct, Judge Wolf stated, defendants' repeated misconduct occurred despite 2 orders to review their document production and, if necessary, supplement it as required by Federal Rule of Civil Procedure 26E. Mueller twice submitted affidavits representing that he had complied with those orders. He also stated Red Wolf has been seriously prejudiced by defendant's misconduct. That misconduct has also seriously injured the court's ability to manage this case and others on its docket. As a practical matter, entering default judgments against BIA and Mueller is the only viable Rule 37b2 sanction. As a result, he assessed a default judgment sanction against the defendants and instructed plaintiff and defendants to negotiate on damages. So, Mary, one of the defendant's contentions was related to difficulty of producing information out of Slack. Do you think that was a legitimate issue or more of a dog ate my homework excuse?
Well, right now, Slack has a discovery center. If you Google eDiscovery and Slack, you'll see a long list of providers that have API access to Slack, and eDiscovery providers, that is.
Mm-hmm.
In 2019, that probably wasn't the case. No, it's not, I don't think it's a legitimate issue. Slack is ubiquitous, and it was ubiquitous back in 2019, but it was a little more awkward to produce from it, I think.
Sure. And I think obviously you do have to have some knowledge and skill even when you're using an API and using a platform that has it to know what to pull and how to do it and so forth. But yeah, absolutely, it does seem that it was maybe a little bit of dog ate my homework excuse. Hard to say because we weren't there. But Tom, many of the issues with the Slack production and the smoking gun message were identified when the plaintiff's forensic vendor was able to review the Slack archive. So at what point, when discovery issues arise, do you think it's appropriate to request forensic inspection of ESI to help resolve those issues?
Well, I think typically when you're dealing with something of some technical complexity that requires a deep dive into the material, it's not a question of just give me the native files and I can look at those myself. We need somebody who can examine whatever it is that's being contested here and tell us exactly what went on. Certainly, and also additionally, if there's a contention that something was spoliated or removed or deleted either inadvertently or inadvertently. But in this case, I think the defendant brought him on the cell. I mean, the dog ate my homework excuse kind of bit him in the butt, right? I mean, it was too technically complex. Well, okay, Your Honor, then let's have a forensics guy go in there and see what's going on. They can't even do it themselves. Well, we'll help you out there. Let's be cooperative and ask for an expert to help you with that technical complexity. And so I think you got to be careful how you argue these things because you may in fact open the door for a forensics examination.
Hey, that's a great point, Tom. I hadn't looked at it that way, but yeah, it's actually a great point. And certainly
you might almost say, Doug, that it was a horse of a different color.
It was a horse of a different color, indeed. And I have, when I read this case, I kind of thought a little bit about the old Victor Stanley, Judge Grimm, the game that couldn't spoliate a straight case, which was the very first case I ever blogged about, actually. But it's kind of interesting that as much as they did, they still let some very damaging ESI be discovered, and the great point, Tom, that their difficulties may have been one of those cases where they should have figured out a way to get it to muddle it through. So, great point. So one of the things I found interesting about this case, Judge Peck, is that it's a rare default judgment based on Rule 37b2, not 37e. Are you surprised that Judge Wolf issued the default judgment sanction in this case on those grounds?
No, I'm a little surprised that he didn't do the belt and suspenders of saying, both or either, so the appellate court couldn't reverse on one without having to deal on the other. I mean, this was an absolutely clear-cut violation of court orders, at least two. That's what 37b2 is all about. It's, the more serious version of what I've talked about on our monthlies before, which is, unwritten rule 1.1, don't piss off the court. Here also, while some of the material was missing, a requirement for 37E, the Slack channels, certain Slack channels were missing, but a lot of the Slack information was found by the tech vendor that was brought in. So it wasn't lost, which is the predicate before you get to 37E1 or 2. There was probably enough that was destroyed and therefore lost that you could get in to 37E2. And I probably, if I were writing this, would have used that as an alternative supplemental rationale. But 37B fit perfectly.
Yeah, it certainly seemed to. And I guess you could say that the plaintiff's litigation vendor picked up the slack on discovery in that case. Oh, I know. Come on. All right. So we do have a couple of questions I'll get to in a minute, and since we are at the top of the hour, but first to the contacts page. And we do have a date for our next case law webinar, which is on not just any Manic Monday, but the Manic Monday of all Manic Mondays, Halloween. So be very afraid of all the puns I'm going to use in that one. But in the meantime, we do have a couple of additional questions. So let's get to those. So back to the 502D cases. Here's one. Peril of privilege is a given. What can be done besides 502D to protect your client? Clear protocol and or QC? Anything else? Thoughts, panel?
Lots of QC. I mean, what often is done is first level review identifies anything that could possibly in a million years be privileged, marks it as privileged subject to further review, and then you have higher level attorneys, possibly the case team attorneys, looking to see what is really privileged and what isn't. Getting a good list as complete as possible from the client of who the outside and inside counsel are that could possibly have been involved is something else that's useful, because then you can, in QCing what is being produced, look for the names of outside counsel, and unless it's outside counsel writing to opposing counsel, it could very well be a privileged document. Lots of techniques like.
Did we lose Judge Peck?
Sounds like it.
I thought I just finished speaking on it.
Oh, okay. All right. It just seemed to end suddenly. Maybe it was because I was reading the next question and trying to get a jump on that. My apologies.
That's okay.
So another question under Rule 502D, what reasons would counsel file a motion to have what normally would be decided responsive docs to be either priv or work product waived for protection? Under what circumstances would a waiver be either approved, ruled on, or denied?
You faded out, Doug.
Oh, sorry. Can you hear me now?
Yeah.
Okay.
Yes. So let me answer. I didn't miss too much of it.
Okay.
502D just says that the act of production does not waive the privilege. It is still the responsibility of the party claiming privilege to prove, if challenged, that it is a privileged document. The issue most often comes up when dealing with in-house counsel's communications with people at that client. Is that really privileged legal advice, or has the attorney switched off their privilege hat and put on their, business counsel or business advisor hat? So the dispute is usually, okay, you didn't waive it by production, but looking at it, there are no attorneys on the email. How is it privileged? There is an attorney, but from description, it sounds like it was business advice, not legal. Those are the things that get reviewed.
Okay. Yeah, that makes perfect sense. So a couple more. Aren't all texts on a phone sequentially numbered and dated within the phone's storage table such that one can identify the presence of deleted text by gaps in the sequential numbering, and also bracket the timing of the deleted text by the dates of the still existing text on the phone? My initial thoughts on that are twofold. One is you're not producing every text on the phone. You're producing certain relevant texts, and production doesn't necessarily mean preservation. It doesn't equate to preservation. So just because they're there doesn't mean you're worrying about producing them. So my thoughts would be that the sequential numbering isn't as important as communications, confirming communications between relevant parties. Anybody have any other thoughts on that one?
No, I think you're spot on, Doug.
Okay. All right. Then we'll move on. A comment here: preserving Slack data is not an issue, but reviewing and producing in usable form is. Slack exports in JSON format, which does not look like the original messages, but instead looks more like HTML code, which is true. Even now, most eDiscovery platforms are incapable of rendering JSON in a format that looks like the original messages. All true, and as Tom would say, that's the other end of the horse. But that is, there are still obviously the challenges with these with Slack and other collaboration platforms in terms of how you actually review and produce that information, because it's much different than email. So certainly a great point there. With that, so let's see. I have one other. Normally, forensic active document collection still precedes potentially responsive documents for those approved custodians. Let's see if let me see if there is any indication of intentional or negligent doc damage. Both sides would argue relevancy or even potential admissibility. Would that require a forensic collection for those data stores based on a learned hand type balancing test? Any thoughts to that comment? It looks like it's more of a comment than a question, but certainly I think that's it's always discovery deficiencies that seem to lead to the potential of forensic inspection in most of the cases I've reviewed. Anybody have any other thoughts on that? All righty. Then with that, I will say thanks to Mary, Tom, and Judge Peck for their terrific insights as always, and I'll turn it back over to you, Mary.
Well, absolutely. Well, what a great conversation, guys. Thanks very much. For our listeners, take a look at the attachments tab. You can subscribe to Doug Austin's eDiscovery Today to keep up with the cases that he's blogging about, and many other things. Learn more about how you can engage Judge Peck of DLA Piper to assist you. Check out Tom O's Spicy Techno Gumbo blog. And up tomorrow, our last in our 5 perfect days of education, is there any right to privacy in modern discovery? And our next rip from the headlines with the Facebook engineers, no idea where all your personal data is. And of course, to solve many of the problems we discussed on this webinar, eDiscovery Today has a great white paper, Getting a Clue regarding eDiscovery project management, that you can download. And then after the webinar completes, check at the top of the console for a link for your certificate of attendance. So I'll add my thanks to Doug, Doug's for Tom O'Connor and the Honorable Judge Peck, and also to Doug Austin for anchoring this insightful presentation over every month. And our thanks to the EDRM community for your kind attention. We'll see you next time on the EDRM Global Webinar channel. Thank you.
Thanks, Mayor.
Thanks, everybody, for attending.
Thanks all.